2014 was Assistant Attorney General Joe Nielsen, who is the national leader of these cases. He and his former section chief, Mike Cole, who's since retired, replaced now by Nicole Demers, who's the current section chief. Mike and Joe went up to George Jepson's office, my predecessor, and said, "Boss, we saw this article in the New York Times about a heart drug called digoxin." And the article basically said that for some unknown reason, the price of digoxin had jumped in a very short period of time by more than 500%. And in the New York Times article, wasn't clear why that was. Why would a drug that had been around for a long time, why would the price jump so quickly and so high? So they asked permission to issue what are known as civil investigative demands or subpoenas, and they put them out there. And at the time, like in most cases, we expected to collect some information and start to pull the thread. But we didn't expect, a smoking gun of any kind, a big revelation. But what we did get as part of that initial investigation started in 2014 were phone records. And you may remember this from when we told the story the first time. We got millions of phone records of cell phones, people talking to each other back and forth. The phone records didn't divulge or contain the contents of what was said on the phone. There wasn't a transcript of those calls. But what it did tell you is who called who, when, and how long did they stay on the phone for. And so we had these phone records back in, when did we get these phone records? 15, around there, 2014, 2015. We got these phone records, and Joe and Mike were like, okay, we've got millions of phone records. What do we do with them? And so they asked Attorney General Jepson to purchase software that the DEA uses to analyze phone records of illicit drug dealers. And they pumped these cell phone records into the software, and boom. What they saw then opened the whole case up. And what they saw was that competitors, over 600 sales and marketing people are covered in this investigation. What they saw was that salespeople at different companies were talking to each other at a high rate of frequency. They were talking to each other a lot. Okay, that's not normal. What they found was that not only were they talking to each other a lot, but when prices went up, right before a huge price increase in a generic drug that was sold by multiple companies, you would see a spike in calls. And so one guy would call another woman at another company, back and forth, people back and forth, talking to each other, and when prices were about to go up, you would see the calls spike, and so they would talk to each other several times a day, back and forth, and the calls would go, 30 seconds, next call, a minute, next call, half hour, next call, a minute, next call, 45 seconds, back and forth, back and forth, back and forth, which is highly unnatural for competitors. First of all, competitors need to be very careful when they talk to each other because they know under our federal and state antitrust laws, it is completely illegal to coordinate with your competitors in the fixing of prices and in the dividing of market share, saying you get to sell to these customers, we get to sell to these customers, and we won't compete with each other. That is highly illegal. That is exactly what our antitrust laws are designed to prevent, and that's exactly what we found. And so this settlement with Heritage is a $10 million settlement. As part of that settlement with Heritage Pharmaceuticals, they were the first company that we really dug into. And two former executives, the former CEO and Vice President of Marketing, Vice President of Sales, Jeffrey Glazer and Jason Malik, are part of this settlement. They've entered settlement agreements with us, and they're cooperating. And as part of this investigation of Heritage, we focused on roughly 15 drugs. One of them is doxycycline. And just to put this in focus, I take doxycycline for rosacea. All of us, I bet many of you, most of us, at some point or another, have maybe taken doxycycline. It is a common antibiotic that was developed more than 40 years ago. Okay, so the time for recouping the cost of developing that drug, testing it, putting it to market has long passed. Everybody made their money back, okay? So why did the doxycycline that I take spike 8,000% over the last decade or more? There's no good reason for it. And one of the reasons is price fixing in the generic drug market. The other company is Apotex. Apotex, the drugs that in focus with Apotex are 6 drugs, and I'm going to try not to mess this up. I was practicing before. Pravastatin, which is a cholesterol medication. It's a common cholesterol medication. It's a high volume medication. And that is the core of our investigation and prosecution against Apotex. And so together, these settlements total $49.1 million. These are the first 2 settlements. This is a breakthrough in this case. We've been working really hard since 2014. We filed our cases in 2016 under a previous Attorney General. I became Attorney General in 2019. We're in 2024, so this has been a long road. And for these many years, closing in on 10 years now, Joe Nielsen has led the way. Him and his team. Connecticut has led the way of a coalition, led the coalition of 50 states, territories, and the district. So I just want to go back again and cover a couple more points, and just note that this investigation has covered over 20 million documents. I said 600 sales and pricing employees and executives in the generic industry. And what we found was not just the phone records, the highly unnatural and now we know illegal rate of communication between competitors. We know that they, at industry conferences, golf outings, cocktail parties, girls' nights out for industry people and competitors, that at these conferences, on phone calls, they illegally colluded to set prices at unnaturally high and unreasonably high and illegally high prices for all of us to pay. They also colluded to not compete with each other, and they used terms in emails and communications like, let's make sure everybody gets their fair share, let's play nice in the sandbox with each other, let's not undercut each other and compete the way you're supposed to. And that was the design, by the way, of the generic drug industry, which Congress enabled in the 80s. The whole point was when drugs came off patent and multiple manufacturers set out to make the same drug, they will all compete and prices would come down. Instead, prices have gone up to levels nobody ever anticipated. I should also note that the states, the 50 of us, states, territories, and the district are putting together a program to get money back to consumers. So if you bought certain generic prescription drugs in the United States between January 1st, 2010 and December 31st, 2018, there will be a process for customers to make claims to determine your eligibility. This will be in the press release, but there's a phone number, toll-free, 866-290-0182. There's an email, info@aggenericdrugs.com, and there's also a website, www.aggenericdrugs.com. How do you find out whether you're eligible? Well, you got to look at your prescriptions and then look at the bottle or tube. So I know, for example, that I have a generic form of doxycycline. I also use this is too much information, but a topical, which is called Metrogel or Metronidazole, and that's made by Taro on my little tube, which is another company that we have sued and are pursuing. And so these 2 settlements, again, break this case open. They're a breakthrough for us and sends the message that not only are our cases well developed and based on strong facts and strong claims, but it demonstrates that these companies know, they now know, and they're beginning to recognize that they have serious, serious exposure and liability for their misconduct. And we're preparing now for trial here in Connecticut. So these are national cases, but the first trial will be here in Connecticut federal court, and it'll be led by this team in the very near future, and that will be related to dermatological drugs, topical drugs. Let me thank our team, Joe Nielsen, and then Nicole Demers, our section chief, Alex Frisbee, Kyle Ainsworth, Kara Moody, paralegals Gail Coloresi, and then also former team members. I want to acknowledge their work because this has been going on for a long time. Assistant Attorneys General Laura Martella and Christine Miller, and our retired colleagues, Assistant Attorneys General Mike Cole, Rachel Davis, and Tony Conti.
And we also want to thank Josh Britt, AAG Josh Britt, who's up here with us.
Josh Britt, where's Josh? Thank you, Josh, also for being a part of the team. I just want to say, as the Attorney General, it's a great honor to lead a 50-state territory and the district coalition in what is the largest state AG-driven antitrust case in this country today, maybe in history. But I obviously don't do this alone. I don't do most of the work. Most of the work is done by this team. And I just want to say how extraordinarily proud I am of their work, of their perseverance, of their persistence. It's a real honor to support them and to work alongside them and to try to get them what they need to help the American people in confronting what is one of the most difficult financial burdens any of us face, and that's the cost of healthcare and prescription drugs. So with that, I'm happy to take questions. Thank you. Yeah. Is this just a small sliver or a big chunk? Or how yeah, this is relatively small. So when we first went after Heritage, it seemed pretty big to us at the time. The evidence was very compelling. We had these phone records. We got to these two executives. They are not cooperating. And the story they had to tell was frankly incredible. You know, when you hear this for the first time, nobody at a big company, much less national, international company, multinationals, nobody doesn't know that you can't collude with your competitors. Everybody knows that, right? That's the whole point of our antitrust laws, federal and state. You can't get together with your competitors and say, hey, what do you think the price of doxycycline should be? And let me tell you a quick story, if I may. When I first became Attorney General, we were having a meeting with a company that is a subject of our investigation and prosecution. And it was me, Joe, a couple other team members in a conference room in our old building, and like 15 lawyers from the other side, okay, from the biggest firms on earth. And I said to Joe, the first thing I whispered to him was, I wonder how much this is costing this company per hour. You know, these 15 lawyers, and these weren't like junior associates. These were the big dogs in the room with us. And I walk in, they say, oh, Mr. Attorney General, so great you're here, okay, because we want to explain to you why we're not fixing prices. And we have a story to tell about this common drug, and let us tell it to you. Great. So I sit down and they start telling us their version of the facts and why they're not fixing drugs on, fixing the price of azithromycin. Okay? So they're talking and I start to lose focus a little bit because I'm trying to remember, like, what is azithromycin? I've heard that term before, azithromycin, I can't even say it. And I'm thinking about, and they're prattling on about why they didn't break the law. And I turn to Joe and I say, hey, Joe, what's azithromycin? And he says, General, you have kids? I said, yes. He said, Z-Packs. And I said, they're fixing the price of Z-Packs? And he goes, totally. And that's what we found here. It's almost, it's inconceivable that there could be such a vast and broad set of conspiracies. There are a number of different conspiracies that are all each individually the subject of our cases. And so when we hit upon heritage, we thought we had hit, in a way, the mother lode. And then we realized there are even bigger players than heritage. Taro, Teva, Sandoz, Mylan, which is now part of Pfizer, right? So those are big names. And you know, for many of us, the names of prescription drug manufacturers are not household names, but go home tonight and look at whatever tube or something that's in your medicine cabinet, you'll see these names. And so the big guys, I would say, don't get it yet, or if they get it, they've lawyered up and they're fighting. I think they know they're in big trouble. And Heritage and Apotex said, we're done fighting, we get it. And I think that they saw value in coming to us and coming to Joe and saying, let's sit down and talk about our exposure, and that's why we're getting close to $50 million. So that trial coming up that focuses on dermatology medicine, that's going to include some of these big companies.
As far as the $50 million and possible future settlements, once the state collects that money, where does it go?
So some of it will go in the nature of fines and penalties, right? And it'll be a distribution among the states according to a formula. And then some of it will go to reimbursing consumers who bought drugs during this 2010 to 2018 period.
Wait, so you said $49.1 million total, and that's for all 50 states?
That's for all 50 states. So just to be clear, it's not all the states. It's 50 states, territories, and the district. So it's most of the states, and then, you know, a smattering of territories and the District of Columbia.
And so do we know how much of that money comes from Connecticut specifically?
Do we know yet? Not yet, no. So the second part of this, and part of my job, and the reason why I spend a lot of time with my colleagues, Democrats and Republicans, is because we have to negotiate about something we call allocation, which is we get in a room, we fight about how we split up the money. So that's not something new. That's uniquely our job to do. It's not always easy to do, but we're working through it.
Gotcha. So the share coming to Connecticut will be like relatively small. So you view this as like kind of more of a symbolic victory?
No, this is a huge victory for consumers. Again, this is not sort of a marginal public policy issue. It's not something that, oh, you know, I wish we could address it, and you know, it's great that we can. This is like core impact on consumers and on Connecticut families. This is a core issue for all of us and how hard it is these days to raise a family, run a business, try to just get ahead a little bit, save some money, buy a house. I mean, the cost of prescription drugs and the cost of healthcare broadly, it's hard to imagine a bigger drag on the wallets and bank accounts of the American people than this. So, and this answers, as I said, a core question. Why are prices so darn high? And the reason why is in part because in the generic industry, which is 90% of all prescriptions, prices for a long time were fixed and rigged. And so, look, I know this group is used to really big numbers from the opioid and addiction crisis. Those are different cases. And those are more in the nature of consumer protection cases. These are antitrust cases. Antitrust cases and damages follow a much stricter formula for assessing damages. And you have to take into account how many drugs, when they were sold, how many prescriptions, how many consumers. So it's much more technical than in other contexts. So it's not apples to apples to say that these cases should look like those cases. They won't. But these are big numbers in this space, and these are the smaller players, and we haven't gotten to the big players yet. So we expect much more significant recoveries in the future because we believe so strongly in our cases.
Do you think the numbers are big enough to like meaningfully dissuade these companies from similar practices in the future?
Yes, I think two things. One is, not only is there a strong deterrent effect from these settlements, and it's sending a message to the rest of the industry, but there are strong, what we call injunctive terms in these settlements, basically obligations, undertakings that the companies agree to, so they don't price fix in the future. And so there's a number of key injunctive terms that will make sure that these companies don't do this again. As I said when I first took over this case, one of the things I struggled with early was, if they know it is illegal on its face, if they know it's wrong to call a competitor to fix prices, why'd they do it? And part of the answer is because this short-term myopia, I want to make my bonus, I'm trying to make money, and fine, I get that, but still, like, it's so illegal. Why did you blow through every guardrail and do it anyway? And my concern is that in this industry, like many of the industries that we take on, are not too big to fail. They're too big to care. And that this is the cost and the price of doing business. So if your question is whether I'm still worried about that, yes, of course I am, which is why we've taken the lumber to them as aggressively as we have, because we have to do everything we can to send the message. And part of that is hitting them in their pocketbook. Part of that is the injunctive terms. Part of that is continuing to be aggressive and going after the other companies. And frankly, part of that's me standing here and shaming them. Anybody else? All right, thanks everybody.